Hello. It's really lovely to be back here in person after 2 years of absolute craziness. We come back to what is, and I put in quotes, the new normal, a phrase that really sometimes annoys me, but I think is just so apt. In the last 2 years, we have seen arbitration, or the sea elephant, whichever way you decide to put it, having come a long way and morphed into what can be almost a different beast. We see that particularly as Indian practitioners when you consider what is the stereotypical ad hoc domestic arbitration, which is beleaguered by a cumbersome process, and the international practice, which is moving to a completely different extreme. And therefore, our panel today is going to discuss the emerging trends in international arbitration. And that suggests that this beast that is international arbitration is really the way to go. And I think some of the views today will help you decide. I think it is. I think there's a huge difference between the domestic practice and the international practice, and as Indian practitioners, you almost wear two different hats depending on what kind of arbitration that you're doing. But so today with my panelists, and I am not going to introduce them like Kevin, you can read about them all in the program before you. We're going to cover very distinct topics. And we'll be touching upon ad hoc and institutional arbitration. Is institutional arbitration on the rise in India? I talked about the ad hoc process. Why institutional arbitration? In the post-COVID world, is mediation becoming more relevant? We're all used to seeing dispute resolution clauses which have a 30-day amicable negotiation period followed by arbitration. But is the very successful Singapore's ArbMed-Arb provision something that we're going to see a lot more in the future? What about arbitrability? That's something that is a key issue, and it was also slightly touched upon in the last panel. In India, that is critical. Singapore, for instance, and I'm going to keep referencing Singapore because after all, we are at an SIAC event, and Singapore is our preferred seat of arbitration. Therefore, arbitrability becomes very relevant. There are several disputes in Singapore which are arbitrable, which may not be arbitrable in India. How do we see those? Illustratively, arbitration of derivative claims. Arbitration and financial institutions. Are we seeing a global move by financial institutions who really have looked at court litigation as the way to recover their monies? Is arbitration becoming more common? Then we have transparency, and of course, the flip side of the coin, confidentiality. And we end with arbitration in a post-COVID world. So that's a lot to cover, and my panelists have broad shoulders. And so I'm going to start off with Nitesh. Nitesh, over the last several years, India has seen a concerted move towards institutional arbitration. And that has government backing, as we've seen from the high-level committee that was constituted to give a push to institutional arbitration. And my question is institutional arbitration a no-brainer? What are the emerging trends in India? Is it to be preferred? And if so, what really needs to be done to encourage the use of institutional arbitration across the board?
Thank you, Shani. Hi, good evening, everyone. Those who are still having some tea and coffee. Interesting topic, ad hoc as well as the institution arbitration. But before that, I just wanted to, put some statistics, before all of us. So as of May 2022, there are around 47 million cases pending before the Indian courts. This is excluding the cases before the tribunals as well as the arbitration. So that's the amount of cases which are still pending. Of course, a lot of cases are commercial cases, right? So despite various reforms before the Indian courts, there is still a lot of pendency. But it's not only because of the delay, but there are multiple cases every day that are being filed, right? So there are continuous cases that are being filed every day. Uh, India ranked 63rd in ease of doing business, and the major factor over there is the enforcement of contract. I think we were somewhere around 180, 170 plus, but we have come to 63rd. But in terms of but in terms of enforcement of contract, we are still at 163rd ranking, right? So that's where we are in terms of enforcement of contract, and I think government has taken this very seriously. They have come up various, there are various reforms. In the 2019 amendment, if you see the statements and the object, it says clearly that the idea is to promote institution because the institution arbitration can certainly help in reducing dependency. So therefore, there's a clear indication as far as the government is concerned that they want to promote arbitration. They have incorporated various provision under the Indian Arbitration Act, right? So that is as far as the government is concerned. If you see how the courts are reacting, they certainly want to promote arbitration. They certainly want to promote institution arbitration. The interference as far as the Indian courts are concerned, I mean, it's gone to very, very minimal. We used to talk about, 10 years back in terms of how the courts are interfering in the arbitration, but I think that scenario has changed completely. We have been, so as part of the firm, we do advise in terms of incorporation of, the arbitration clauses in the transaction documents. And we have seen foreign parties insisting, no, we want to retain the jurisdiction of Indian court for the purpose of Section 9. So do not exclude Section 9 because we want to go before the Indian court. So that shows in terms of the confidence as far as the Indian courts are concerned for the purpose of Section 9, right? The 2019 amendment proposed the Arbitration Council, right, which is, of course, yet to come. It's a separate debate whether do we need government interference in the arbitration system, in the institution arbitration system? But yes, there is a proposed, there is a proposed body, which is the Arbitration Council of India, which will, of course, look after all the institutions as and when, it comes into effect. Apart from the MCI, which is in Bombay, we have got the new arbitration institution in Hyderabad. These respective state governments are promoting, the respective institutions in those states. Like we had the MCIA in Bombay, the Maharashtra government, they promoted, right? Telangana government is promoting the new institutions in Hyderabad. So there is certainly, requirement for institution arbitration. If you want to promote arbitration, it can't only be ad hoc arbitration, it has to be institution also. But certainly for the size of a country, right, you can't have one institution or two institutions running up the entire institution arbitration. You certainly need several institutions. If you have to ask anyone if somebody has to ask us, whether should we have ad hoc or should we have institution, what are the criteria? So, according to us, there are three. First is quality, second is speed, third is cost, right? Not in every commercial dispute you need an institution to govern it, right? And if you have to have 47 million, let's say assuming even 20% of those cases are commercial cases, you certainly can't have any institution taking up all those cases and deciding the arbitration. That can't happen, right? So for few cases, certainly I think ad hoc works. But most of the commercial disputes, which involves most of the commercial transaction, they certainly need good institution. Where you have the government support, where you have court support. So where I think we need is a lot of support from the arbitration community in order to promote the institution arbitration. So why institution, right? There are various factors why we should have institution arbitration. We all know the institution arbitration, they come up with their own framework, right? So you don't have to, worry about what rules, what will happen to the arbitration appointment. Because majority of our litigation, right, in terms of ad hoc is around Section 11, which is to appoint the arbitrator. I think the entire Section 11 can go away if you have the right, institution in place. They take care of all the preliminary issue, right? We talked about consolidation, we talked about joinder, we talked about seat-related issues. All those can be taken care of if you have institution arbitration rules in place, right? Constitution of tribunal, of course, I mean, the institutions takes care, I mean, let's say if you have SIAC, they'll take care of the conflict situation, they'll take care of the the independence, the neutrality, all those, these situations are taken care of. The conduct of the entire arbitration, whether it is communication, the secretariat, everything is taken care as far as the institution arbitrations is concerned. Managing finances, whether it's cost, expenses, the tribunal's expenses, deposit, everything is taken care of. Award and termination, because the secretariat, the institution will certainly proofread, right, the award, and they will, release only once they are convinced in terms of what the award is. There is an entire administrative setup. There is confidentiality. A lot of rules now incorporate third-party funding provisions. So we have ICC. They have a specific provisions on that, right? The institutions, it's easy to adapt, changes, whether it's virtual, whether it's COVID situation. So all these factors shows how institutions arbitration will, take care of the entire situation if you actually intend to do arbitration. Now, in this background, if you have to compare ad hoc arbitration, right, which is where you'll wonder, how you do, given all these circumstances, how do you actually now do ad hoc arbitration? So institutional arbitration certainly, is the next step, which is why, SIAC should certainly take lead, being a successful institution, right, in terms of how the institution arbitration, as far as India is concerned, can become more successful.
Thanks. Nitesh, so that's a lot of work that the institution does. Is it more expensive than ad hoc arbitration in India?
So, a lot of ad hoc arbitration, right? Of course, we have Arbitration Conciliation Act that has got a fee schedule. A lot of ad hoc arbitrators who get appointed by the courts, right? There is the first question that an arbitrator will ask is whether that order says that I have to be bound by the Arbitration Act. In most of the orders, you will see that they are not bound by the Arbitration Act in terms of the fee, right? As I said, not every case needs to go to ad hoc, or not every case needs to go to an institution, right? When there are big disputes, right, I think the appropriate forum has to be an institution, because, apart from the cost, what is relevant for those disputes is the speed, is the quality, right, which is where it becomes preference. And of course, Siddharth can add more, representing an institution in terms of what, matters as far as the institution or ad hoc is concerned. But I think cost is certainly a factor, but that's not a factor that is required to be taken into account in every arbitration.
Okay, so I am going to come to Siddharth. He's here. Yeah. But before I do, I have a quick comment, because I am going to give Siddharth a bit of a nudge as a client, although he has worn two hats. And that is that in practice, I've actually seen that institutional arbitration, and I'm not talking about just Indian institutionals. Institutional arbitration, of course, we all know that it's more efficient, it's more streamlined, but it can actually be cheaper than ad hoc arbitration, because there is a fixed timeline within which the arbitrators push to finish. And I have been in ad hoc arbitrations where my witness has been cross-examined for 11 days, when I don't think he should have been cross-examined for more than 1.5. So actually, and Siddharth, maybe that's something you can comment on, having worn both hats, I find that institutional arbitration can actually be cheaper for the client. So that's a comment which you can think about, but I have one more question for you. And that, as having practiced as a litigator and now being a client, how has that helped you evaluate your dispute resolution clause in a contract? And do you have a preference for ad hoc or institutional? And also, to put you on the spot, between institutions themselves.
That's an unfair question.
Which you may not answer if you do not want to. If it's not SIAC, don't answer it.
So, see, institutional versus ad hoc, I think the advantages of institutional arbitration, it's a no-brainer, what Nitesh just pointed out. In my experience now as heading the legal function in a corporate house, I feel, or what you see and as a practice, in all the international commercial arbitration or wherever the counterparty is non-Indian, I think institutional arbitration is the norm. I have not come across any clause where an ICA is ad hoc, but domestic arbitration clauses or agreements which are low stake, not very high value, uh, usually the arbitration clause does not provide for an institutional framework. One reason could be that most of the times in these agreements, the boilerplate clause that gets used does not refer to any institution, but many a times it is deliberate, and I don't see anything wrong per se with ad hoc arbitration because, again, insofar as the timelines are concerned, or the delay part, that is largely addressed because of the timeline that's prescribed in the Act now. Of course, that you can go and seek extension, but timelines are there, and that has put some discipline. Secondly, ad hoc arbitration, in my view, doesn't mean that you conduct it in an ad hoc fashion. I mean, ultimately, like you said, that 11 sessions for cross-examination. Ultimately, it boils down to who the arbitrator is. If Mr. Khambata is the arbitrator, and I don't mind if it's ad hoc arbitration. So, so ultimately, you have to, it boils down to how you conduct. Ad hoc does not mean ad hoc in the loose sense of the term that you do it casually. And given the data points which Nitesh pointed out, given the number of cases, we also, at least in India, we lack the ecosystem for all institutional arbitration. Coming to your second point in terms of choice of institution, so I'll be politically correct, but even honestly, I think most of the contracts, SIAC and LCIA, in my experience, they compete with each other. Yes. Thank you.
Thanks. So for ad hoc arbitration, really the key is if you do have to go for ad hoc arbitration, make sure you've got a robust tribunal.
Yes, yes, yes.
Shanine, can I just make 2 points?
Yes, please.
I think there's a common misconception that when you go to a institution, it adds to your costs. And that's not true, because the reality is that the percentage that the institution takes is extremely small, and I think it's no more than 2%, if I'm not wrong. The second thing is there's a value add that, certainly speaking with my SIAC hat on, there's a value add that SIAC adds, which is scrutiny. And that in the long run saves you, or could potentially save you costs, because it helps ensure that the award that you get at the end of the day is enforceable. And that's really what you want. Thanks.
Thanks. Stick with that mic, Siraj, because I'm coming to you next. The world's gone through 2 crazy years of COVID, of civil uprisings, of war. We've seen a global economic recession. We've seen clients tightening their belts. With it, we've seen the rise of third-party funding. Have you also seen the rise of mediation? Is there more of a reluctance to press the trigger for a big-ticket litigation or arbitration? Is that because of a recession, of a tightening of belts, or is that a more willingness to embrace a formal mediation process? And what value do you think that a formal mediation would bring to a dispute and to an arbitration?
So the first point I'd make is, I think speaking from a Singapore perspective, and a lot of my friends and colleagues from Singapore may agree, is litigation didn't decrease during COVID. I think a lot of us were as busy and perhaps sometimes busier because people just found a way around the inability to travel, or maybe people were just sitting at home with nothing to do and decided, let's start a claim, let's prosecute a claim, and things started happening a lot faster. So that's the first point I make. The second is, at least in Singapore, since the Singapore Convention came on board, there's been a spotlight on mediation, not just in Singapore, but globally. And there's been a greater focus and a push for parties to look at alternative ways of resolving disputes. And I'll give you an example. In Singapore, we've just introduced a new set of civil procedure rules. And it was introduced on the 1st of April. It was not an April Fool's joke, unfortunately. But one of the key pillars in this new rule is that parties are mandatorily required to consider alternative dispute resolution before they commence proceedings, during the course of proceedings, and during the course of any appeal. So that's now entrenched in our civil procedure rules. So what you're going to see is, I think, people being forced to look at mediation and other alternatives to going for litigation. And I think moving forward, clients may also look at mediation more favorably. And I say this having looked at a recent survey that was released by the Singapore International Dispute Resolution Academy, SIDRA. And what they did was they examined how businesses and legal representatives looked at or decided how they would resolve their disputes, whether by arbitration, by litigation, by mediation, or a hybrid of these various mechanisms. And in terms of the choice of dispute resolution mechanisms, by far and away the leader was international commercial arbitration. I think 74% of those interviewed picked commercial arbitration. Next was commercial litigation with 49%. I know that doesn't add up to 100, but it was because people were given more than one option. Then came hybrid dispute resolution and then mediation. But the factors influencing the choice of mechanism is interesting. The highest, or rather the most popular factor was enforceability with 71%. Then came neutrality or impartiality, costs, and lastly speed. These were the top four. So enforceability was at the top of the list, and if you think about it, that makes sense, because if you go for a process, you want something at the end of that you can enforce and get substantive relief. But it also looked at why people chose mediation. And the top four, again, was impartiality, speed, confidentiality, and flexibility of the process. Enforceability, interestingly enough, for people who chose mediation was the second lowest at 67%. Now, what the Singapore Convention for Mediation does is it improves that enforceability. It seeks to give to mediated settlement agreements what the New York Convention gives arbitral awards. And so if you combine the fact that enforceability is a key factor in people choosing their dispute resolution mechanisms, and you merge that with the fact that now increasingly mediation agreements are going to have some teeth, you can possibly see a movement towards more parties choosing mediation as a means to resolve disputes. There are hurdles. The first one is enforceability, as I've said. That's being addressed, or hopefully will be addressed by the SEM. The second is perception. And Kapish, if you're here, I'm going to borrow your example. And the example is, look, if there are two CEOs who have discussed this and have not come to a resolution, what's the point of going for mediation? And that reflects a failure to understand what mediation does, and you know, the specialist knowledge and skills that mediators bring. And the third, I think, is what I would term a mentality or perspective issue. And there's a tension between the candor that is required in mediation, parties being able to share what their interests are, what their real concerns are, versus a human instinct to not want to show your cards, because those cards may be used against you. So I think mediation will have an increased appeal to users, but there are hurdles which will have to be overcome. What is the role of mediation after arbitration had been commenced? I think, Shanine, that was your question. And I think the fact is mediation can occur anytime. And even now, you can use mediation to work for you and your clients. And I'm going to come back to something you mentioned earlier, which is the SIAC, SIMC, ARB protocol. And how that works is you start an arbitration with SIMC. It's then moved, with SIAC. You then move to the mediation center, and you have 8 weeks to try and resolve that dispute by mediation. And if it's resolved, then it comes back to the arbitrator. It's a consent award that's recorded, which is enforceable just like any other award. If it's not, then the arbitration goes on, and hopefully, and at the end of that process, the arbitrator makes an award. So I'm going to stop there, and hopefully that's answered your question.
Thanks. Nitesh, I'm going to come back to you. So India was actually one of the convention's first signatories. It's not yet ratified it, but there has also been a concerted push towards mediation. We see that in the Commercial Courts Act, which mandates mediation prior to filing a suit. And we also see that in the draft mediation bill that was issued last year. So what do you perceive to be the future for mediation in India and generally?
I think the reason why India is so far not ratified is because I think they want to do the domestic act first. Because on the lines of the Singapore Convention, there is a mediation bill that has come in, right, which addresses the enforceability issue as far as the domestic mediation is concerned. Of course, the arbitration award is enforceable, but the domestic mediation, the settlement agreement, once this bill is passed, it will be also enforceable as a decree of the court. The other features of the mediation bill is it makes the mediation process mandatory. It gives 180 days for the purpose of resolving through mediation. Interestingly, it says you can terminate only after 2 sessions, right? So therefore the purpose is to keep pushing the parties to resolve through mediation, and it's not that after 1 hearing you terminate. It has to happen after 2 hearings. It will also override the other laws. I think there'll be parallel amendments to the Indian Contract Act as well as the Arbitration Act, so that the mediation becomes more powerful. And I think practically all of us we have seen, and Rajendra and I, we are advising a common client, wherein I think there is a lot of interest as far as mediation is concerned. Although arbitration has been invoked, we are, what Siraj mentioned about the AMA protocol is something we are following up. But if the mediation convention was ratified, and if the settlement agreement was followed, then there was no need for doing the arbitration route, right? Then you straight away go for mediation and do it. So I think from the commercial point of view, from the parties' point of view, in every dispute resolution clause, there is always, to a larger extent, there's always a reference of parties trying to resolve it through mediation. Even if parties are able to, right, then the consensus is let's at least invoke arbitration, get a consent award, so that way it becomes binding, right? But I don't think you have to go to that route anymore once the settlement agreement through mediation becomes, enforceable. So I think mediation certainly will be, very, very advantageous, and it can actually, I personally see that once it actually, the bill becomes an act, right, and the mediation is given some more time, it can actually, replace arbitration for all the reasons.
Thanks, Nitesh. Moving on to the issue, one of the issues of arbitrability, and that is in relation to arbitrability of derivative claims. Siddharth, as an in-house general counsel, what are derivative claims made on behalf of a company? And how are they viewed in India? Are they recognized and are they arbitrable?
So I'll come to the scale of use, but conceptually, derivative claims are where a shareholder basically becomes the medium to enforce the rights of the company for the benefit of the company. Now, sometimes we see representative claims being is being used interchangeably for derivative claim, but they're different because representative claim, it's just a combination of identical claims which are sought to be adjudicated in a common forum. But derivative, the medium doesn't have a direct interest the medium or the shareholder who's petitioning the forum is not claiming any direct benefit for himself. Now, in terms of scale of use and whether this is permissible, now derivative suits are permissible, and courts in India have held them to be maintainable. The classic rule that only company, the aggrieved party can sue, I mean, exceptions to that rule have been recognized. But in terms of scale of use, how often this action or the remedy gets invoked, I'm not sure, because suits in India, they move at a very, very slow pace. So derivative action, I mean, the closest to derivative action that you see is then oppression and mismanagement cases. Now again, oppression and mismanagement cases which are done within the framework of Companies Act, they're not truly or purely derivative, because it becomes hybrid. There the petitioning shareholder is claiming for himself and also for and on behalf of the company. But that's the closest derivative action we see. And that brings us to the question of arbitrability. If the party who is suing is not party to the arbitration agreement, then can that party invoke the arbitration clause to which the ultimate beneficiary is a party? So let's say if company is party to an arbitration agreement, and as a shareholder, I am stranger to that arbitration agreement, can I then invoke that arbitration clause and then initiate arbitration on behalf of the company? On this, again, it remains a gray area in India. At least Bombay High Court has taken a view that, and there has been a bit of flip-flop, but at least Bombay High Court has taken a view that it is arbitrable. Calcutta High Court said no. But again, even in these decisions, and I'm a bit nervous talking of judgments sitting next to Mr. Khambata.
Go ahead. My lips are sealed.
Yeah. Yeah. But I see that even on the arbitrability question, there are two components. First of all, I must clarify. One is the entry point, whether there exists an arbitration agreement. That is one component of arbitrability. And the second is subject matter arbitrability. So even if there exists an arbitration agreement where the subject matter of the dispute is arbitrable. Now on the first point, of course, Bombay High Court, as I said, has kind of taken a view that it can be done. But there also the decisions, in the facts of those decisions, one finds that the court has used the interconnectedness principle to allow arbitration. So for instance, if there are a bundle of agreements and the petitioning shareholder is party to one of those, not to all, and the company is party to some other agreement, and the court looks at all these agreements being interconnected and then allows the petitioning shareholder also to agitate claims for the benefit of the company. Now, this I feel is a tenuous test, because ultimately while derivative suits one can't quarrel with, but in arbitration, if you simply apply the principle of shareholder getting into the shoes of the company and invoking the arbitration clause, even when the shareholder is not a party to the arbitration agreement, then conceptually, I think it goes against the grain of arbitration, or the starting point of arbitration, which is consent. Now, arbitration is about choice. And when I enter into an arbitration agreement, not only I decide or I choose to decide what I will arbitrate on, I also choose to decide who I will arbitrate with. And in a derivative action, if you allow a shareholder who is a complete stranger to the arbitration agreement, then the test from pure arbitration law perspective, I'm not sure if one can really say with certainty, with a doctrinal basis, that it should be made arbitrable. Of course, I believe Singapore or in the US, there has been a liberal approach to this whole issue. As regards the second issue about subject matter arbitrability is concerned, and there we have had cases where, for instance, operation and mismanagement cases can be referred to arbitration. On that issue, I feel there cannot be and there should not be an absolute yes or no answer. Ultimately, it will depend on what the claim is. If, let's say, the alleged act of oppression or mismanagement arises purely out of a contractual breach, and if that contract has an arbitration agreement, then it should be referred to arbitration. But if the claim or the allegations go much beyond, and they are the classic operation and mismanagement cases, then perhaps the test that applies to arbitrability of any other claim should equally apply to a derivative claim. And insofar as the tests are concerned, we had the Booz-Allen test, but in 2021, Supreme Court has, a 3-judge bench has now further clarified and laid down a 4-fold test, which is on the lines of Booz-Allen, that it should not be an action in rem, it should not, the subject matter of the dispute should not relate to third parties, it should not relate to sovereign function of the state, and it should not be barred by a statute. So the same test should apply to a derivative action as well. And on this, I feel that again, I'm taking the operation mismanagement example because that is what one sees closest to a derivative action. If the claim is dressed up to avoid or frustrate arbitration, then that is where the judicial mind comes into play, and that is where a court which is hearing a reference application must see and assess whether the party who is seeking to avoid arbitration is doing just for the heck of it, or really the disputes do not warrant reference to arbitration. In the 2021 judgment, 3-judge bench decision of the Supreme Court, 2 things they have clearly laid down, that in some of the judgments we had that, even though there is an arbitration agreement for complete justice, or justice of the case demands that it should go to normal court, or the dispute is very complex. Now, that Supreme Court now has said clearly no to. So just complexity of the dispute is no ground to ward off arbitration. Similarly, the fact that this should not be the perception that arbitration is an inferior mechanism to a court adjudication, or arbitrators cannot decide this question and therefore it should go to the municipal court. So these 2 principles, at least Supreme Court has clarified, again, in line with the pro-arbitration jurisprudence that we have seen in recent years. Yeah, this is it. I don't have anything else. Thank you.
Thanks, Siddharth. That was actually very insightful. So, Siraj, I'm really also interested in the international view. Siddharth touched upon oppression and mismanagement, which is, we know, is arbitrable in Singapore. Does Singapore recognize derivative actions as being arbitrable? And are there any specific facets of a derivative action that you think make it amenable to arbitration?
So the position in Singapore is clear. There is a statutory derivative action under the Companies Act, and the relevant section provides that a complainant may apply to court for permission to bring an action or arbitration in the name and on behalf of the company. And the words "or arbitration" were expressly included by way of an amendment in 2015. So there's no doubt as to the intention in my mind. Derivative actions, to my mind, are not more or less amenable to arbitration. And I think the key is something that Siddharth said earlier, which is that this is really a question of a shareholder enforcing rights of a company, and for those rights being enforced for the benefit of the company. And so it's essentially the company's rights which are being sought to be enforced. And so the question really is, you look at the claim, does the claim fall within the ambit of the arbitration clause? And you look at the party who the claim is being sought to be brought against, and is that party within the ambit of the arbitration clause as well? So I think that's the position in Singapore. My understanding, and I don't profess to practice in Hong Kong or Australia, but my understanding is that the position is similar. Certainly in Australia, I know the Commercial Arbitration Act defines a party to an arbitration agreement to include a person claiming through or under a party to an arbitration agreement. So I think that potentially covers a derivative action, although I don't know whether there's anything specifically on that point.
Thanks, Siraj. We're moving on now to arbitration and financial institutions. We were actually going to have the brilliant Matthew Brown from Clifford Chance with us, but unfortunately he couldn't make it. And so I agreed to take on the first question with his very helpful notes. But we're running a little short of time, so I'm just going to make some very quick comments and then ask Rajendra to take over. So banks and financial institutions are almost a different breed of client. Typically, particularly in India, where you see every single commercial contract will have an arbitration clause. It's rare to see a dispute resolution provision talking about litigation in Indian courts, unless it's by a bank or financial institution, where specific courts, our debt recovery tribunal was set up to speed up or ease recovery of monies by banks and financial institutions. And this is something that runs through many jurisdictions, and litigation seems to be what is preferred, except for instance in certain specific kinds of contracts, say for instance the ISDA master agreement, which deals with derivative transactions, or you may see it in project finance. But as there is more and more global and cross-border trade, you see more multi-party, multi-contract, and multi-jurisdictional composite transactions and therefore disputes. And it then becomes simpler to have everything consolidated or parties joined in one arbitration. And we've been seeing some sort of a move by banks and financial institutions now towards arbitration. In India, of course, the issue of arbitrability remains. Our Supreme Court has ruled that where the DRT has jurisdiction, it has exclusive jurisdiction. So parties cannot go to arbitration. Just very quickly, that ruling I have slight reservations about because it does not consider the ruling in HSBC versus Nahar, where the Supreme Court allowed Nahar to file a civil suit notwithstanding the fact that HSBC had filed in the DRT. Now, if a respondent can file a civil suit, why can't the parties agree to consensual arbitration? But that's another standalone panel for another day. The other issue which is not arbitrable is issues that go before the insolvency and bankruptcy courts, and I think that's generally can be said to be relatively a global phenomenon. And the third, with specific regard to India, is issues relating to trusts. So typically you'd see debenture trust deeds or investment funds, mutual funds. Those are, it's been held that they have to go have their disputes decided only before civil courts. So that's generally what we're seeing playing out in India. But Rajendra, today, as a very seasoned litigator and arbitration lawyer, what are your views on arbitration for financial disputes, and do you see the trend reversing?
Thanks, Shannon. Well, certainly. So therefore, there is one bucket of disputes that that you have referred to, which get covered either under DRT, SARFAESI, IBC, or trusts. But then there is a second separate bucket of disputes, which, and we've seen this extensively in English law governed documents, where they lean towards the English courts because the English commercial courts are relatively cheaper and much faster than an arbitration. Now, have we seen arbitration clauses in finance documents? Yes, increasingly they are, they are keen to have arbitration clauses. And I think that again is no different from any standard contract as to why would you prefer an arbitration clause as against a court clause. All the same reasons: confidentiality, faster, specialized tribunal. Now with our new act, a shot in the arm as far as enforcement is concerned. So yes, the trend certainly is leaning towards having arbitration clauses. There are certainly certain franchises, certain industry houses, certain banks who resist it for historical reasons. But I have seen that there are more benefits to arbitration even there. So I am seeing the trend change.
Thanks. Sticking with you, we come to something that has two sides of the coin and is also a recent trend between two factions. One is a push towards transparency, and I think as a practicing lawyer, I'd love to be able to read more awards, and I would love institutions to publish them in some sort of redacted form, or confidentiality. So how do you see the two sides of the coin play out? What are the trends you're seeing, and what are the benefits or the risks of both?
So, one subject which I was going to cover was confidentiality. And I wouldn't restrict confidentiality only to the tail of, to borrow Mr. Paulson, the animal. It's not only the award or whether you publish the awards. I think confidentiality, and we've heard all the speakers speak about the fact that Indian courts are very, very slow, the fact that there is a backlog, the fact that arbitration clauses is a no-brainer in most contracts. But all of it ultimately goes to enforcement. And therefore, what's important for enforcement really is transparency. So I would think that it's not really a transparency or confidentiality. I think they really, to some extent, are animals which get merged somewhere. But I think transparency really starts from the very process. So transparency starts from appointment of an arbitrator. And I've heard Darius speak very, very well once on, I don't know if the exact topic was arbitration mafia, but something similar. So it really starts with appointment of arbitrators. It really starts with your Schedule 5 and your Schedule 7. It starts with of how important it is for the arbitrator to be somebody who's completely unbiased. I was recently speaking to a friend, and I was very amused to know that now when it comes to testing transparency of the conflict of interest for an arbitrator, it really trickles down to stuff like what's your social media? Is he a friend with you on Facebook or on LinkedIn? And does that compromise your confidentiality? So it really goes into issues that you had never thought of. Then it of course goes to your discovery and your Section 27 applications. Very, very important again from a transparency perspective that the process has to be transparent. Reasoned awards, institutions encouraging reasons every time it's possible, even when it's an administrative decision. How do we ensure that there is transparency there? And of course, at the end of the day, how do we make the awards public to the extent possible? How do you read that with our wonderful Section 42A, which is just very strangely worded? How do you sync that with something which is a few sections below, which is 43K, which says that ultimately this arbitration council will have a consolidation of all judgments? So I guess, these are issues that will keep churning. But, arbitration, I think all of us agree, is a no-brainer for all of us. So it's good to discuss this and make it as ideal as possible. So, as they say, हजारों ख्वाहिशें ऐसी कि हर ख्वाहिश पे दम निकले, बहुत निकले मेरे अरमा, लेकिन फिर भी कम निकले. So I think the more you can achieve, the better it is.
And Rajendra, translation for our other friends.
Well, so therefore, desires are unlimited. You just keep thriving for the best. And I don't think that's an accurate translation, because I wouldn't even think that I'll be able to translate Ghalib.
Thanks. Okay, now coming to my favorite council.
Oh dear.
I was going to add to that, and India's go-to council for arbitration. The last 2 years have really been the last 2 years have been out of the ordinary and changed things in a myriad number of ways, including the ubiquitous Zoom meeting. And I'm so happy we're not on another webinar today. But how have these changes, and not just the technology, how have these changes affect the way arbitration is run? And the little crystal ball gazing from you for how you see arbitration in a post-COVID world.
Thanks, Shaneen. I apologize for my voice. It's not because I've been shouting at my wife. It's going to be a little difficult for me to do crystal ball gazing with 5 bright lights shining straight into my eyes. So I'm going to first take a sneak peek at what Rajendra said, something quite different. Whereas all of us would love a repository of published awards, which we could dip into from time to time to help us in the next arbitration, we mustn't lose sight of the fact that one of the main reasons parties want to go to arbitration is confidentiality. And you cannot impose upon them any duty to publish awards. It has to be purely voluntary, and in which case you probably won't get an exhaustive repository. That's a conundrum to which I have no real answer. To wrap up this session, I think, crystal ball gazing. So look, the whole world has gone through COVID and a lockdown. And a lot of people think that we're sort of emerging from a dark tunnel and we are back into the bright light. Of course, to a large extent, that may be true. But as far as practice of arbitration is concerned, I don't think we should look at it that way. I think as far as international commercial arbitration, it was always largely virtual in any case. You had all your pre-hearing orders, applications, hearings sometimes done virtually. Emergency arbitrators, interim applications, discovery applications, most of these were virtual. And it was only the final evidentiary hearing coupled with closing arguments that were physical. And hey presto, what happened? Actually, the arbitration world managed very well because you had arbitrations running. Yes, the more inefficient of us had to become a little more efficient. Documents had to be produced in time. We couldn't spring surprises on our opponents. Submissions had to be filed well in advance. But arbitration actually worked. It worked not only internationally, it worked even in India. Even traditional Indian arbitrations seamlessly morphed into virtual ones. Now, the result of all this is, I think, twofold. One is a whole lot of us realized that this can be done virtually. It's not so difficult. Leave aside all the grouses that we counsel always have about, well, we don't have eye contact with the witness who we are cross-examining, or we can't see the body language of the tribunal. That's true. But by and large, we got our points across, and we got, I believe, just and fair awards with a full consideration of all the issues in the matter. But the second impact it has had, I think, is on clients, on arbitrants. They've said, wait a minute, what we just went through was actually much more accessible. We could log on conveniently without inconveniencing our office schedules. It was cheaper. In some respects, it was quicker. So why are we abandoning the ship? why shouldn't it continue into the future? And I think that's the big question all of us as practitioners and institutions as well will have to grapple with. Whereas all of us love a physical gathering, and we want to all lapse back into that 1 week or 2 week session, the fact is the system and the beneficiaries of the system, the arbitrants, are not going to allow that. Arbitration, like litigation, is expensive. It's expensive even in India. And I heard my learned friend say ad hoc arbitrations, institutional arbitrations. I think for any complex litigation, it's a no-brainer. And institutional arbitration is cheaper. Real-time transcription is cheaper in a complex arbitration. But cost issues are going to become very, very relevant as we go forward. So we cannot jettison virtual functioning at all. There will be arbitrations which will still function virtually. And I think the 2 or 3 main issues or changes that we're going to have to look out for in the future. One is an adaptability to virtual functioning. And as far as Indian lawyers are concerned, that means embracing the written word, making sure our written submissions are cogent, they're detailed, they're concise, making sure we comply with deadlines, making sure we truly invigorate the discovery process, which I believe many of us don't, but really utilize it. Do all of that before that last hearing. And when that last hearing comes, we should be as willing to be able to cross-examine a witness virtually and to make closing submissions virtually as we would physically. I think that's the first change that's going to have to come. And to get a little granular on this, I think even internationally, I think pleadings are going to now shift more to a memorial style of pleadings, which I always felt was more efficient in any case. Because the traditional common law pleading of restricting yourself only to factual submissions and then waiting to sort of throw your law at your opponent right at the end is not going to work in the future. The memorial style where you lay out your cards, both factually, document-wise, and legal authority-wise, so that everyone knows what's on the table, so that issues get crystallized, is going to be the way of the future. I found it works much better, actually. That's getting a little detailed. But one is the way we practice. The second major change, and it was touched upon by my friends here, is third-party funding. We haven't seen much of it in India, but I think we're going to see an awful lot of it in the future. There's actually no restriction on it legally in India, as we know. It's just that there's no regulatory matrix that governs it. But I think we're going to get third-party funding issues that arise because claims are going to be more and more difficult to sustain for several litigants. And if you have good third-party funders, good claims will not get abandoned. And I think that's what's going to happen in the future. The third area, and this is not really COVID-linked, I think it's just a natural progression, is diversity. I think the march to having more diverse tribunals, more diverse counsel on both sides is inexorable. And diversity only doesn't mean gender, it means geographical diversity, nationality diversity, language diversity. Jan spoke very interestingly of the French courts allowing English now. And I think we'll have to break free of all these nationalistic barriers and welcome more hybrid versions of presentations in the future. It's going to be difficult, but technology is going to have to kind of weigh in on this. And we're going to see how witnesses whose first language may not be English might be allowed to depose in the language they're most comfortable with, but with automatic translations, etc. So I think these are the 3 or 4 main areas looking forward. And we've got to remember ultimately, and I go right back to Charles Darwin's Origin of the Species. What did he say? He said, it's not the smartest or the strongest species that survives. It's the most adaptable. And of course, he founded his whole theory on that. And I think that's what's going to happen to the legal profession as well. We're going to have to adapt. And we're going to have to adapt quickly. Many of us already have. Some of us will have to catch up. Tribunals will have to adapt. I don't think there's any going back, even in domestic arbitrations, to 11-day cross-examinations. That's just unacceptable. It's unacceptable because it's inefficient, it's expensive, and frankly, it doesn't make the system any fairer. It's just a fueling of this due process paranoia that some of our tribunals have. It's nothing more than that. So I think these are the ways we're going to look forward in the future. Institutions are going to play a huge role. They're going to lead in many respects. And I think all my friends all around me are going to have to lead. I think, especially as Indian lawyers go, law firms go, we almost need to take a pledge to make our presentations more efficient, shorter, more writing-oriented, time limits on oral arguments, the whole works, the entire works of all this. Because unless we do that, we're going to make ourselves irrelevant. I truly mean this. I see a lot of young faces here, and I think it's the next generation that's going to have to really carry this through. So it's going to happen fast. I don't think we have the luxury of time. I think one thing I can recommend to all of you, I think it should be compulsory reading in law schools, in law firms, law chambers and institutions, are the last 10 paragraphs of a recent judgment of the Supreme Court, written by Justice Sanjay Kishan Kaul, where he finally throws up his hands in the context of litigation, of course. And he says, he bemoans the fact that we just cannot go on in the same way any longer. And he refers to COVID. And he said, this is a case where we've heard oral arguments for 26 hours. We've had filing of written submissions, synopsises, additional synopsises. And he said, that hasn't helped in clarifying things. And he said, a litigant is not going to be able to bear this cost any longer. And we owe it to him now to do a little soul searching and rejig the way we practice law. And I think the big firms should really be path breakers in that. A pledge is one of the usual ways in which this is done, even internationally. So I think perhaps far from what my friend Gary Bourne had once said a few years ago about winter is coming, about international arbitration, I think with correct adaptability, we may actually be entering a golden age, because arbitration is more flexible, it's more adaptable, it can react to the environment in this way. Courts, at least in India, are lapsing back into physical hearings and are not going to be able to grasp the virtual option. So I think arbitration has that advantage. We need to grab it with both hands and go forward. Thanks for suffering this horrible raspy voice.
No. Thank you. Thanks so much, Deb.
Sorry, if I can just grab the moment, Daras, and ask you a question. So, we've seen a very unusual step taken by the Gujarat High Court, where the proceedings are on YouTube. How do you see that? Why should all the courts not adopt it?
I think that's a fabulous step. I think many of us practitioners will have noted that the Gujarat High Court was at the forefront throughout this COVID crisis. They are the first who moved completely onto Zoom, unlike other high courts. They had no allergy to Zoom. They have now completely live streamed all their hearings. And that is very useful because, even in matters in which you appear, for example, where I have not been able to go and hear my opponent's argument, I can hear a clip of his argument, and that can be sort of edited by my team. And so it's so useful. It also makes the court transparent. So I entirely agree with you. I don't see why all courts shouldn't go that way.
Just a point there. So in fact, a matter relating to Gujarat High Court, so the other side got an ex parte order, right? We wanted to see in terms of what was argued, right? And we got to know it's all available, right? So we went there, we saw what was argued, and that we incorporated in our pleading. So that's the advantage of I mean, that was an instant advantage, right?
I mean, the next question that I was going to ask Darius is the law today in India is that ultimately what the order says is sacrosanct. It's not what you think, the judge may make a remark, but that doesn't really become the order. But that will also evolve ultimately with the YouTube presentation.
There we'll have to show a little discipline. Yeah. Because you can't straitjacket judges. They will have reactions during a hearing. You can't say, well, on so-and-so day, transcript, line so-and-so, you said this. How come you decided the opposite way in your order? I don't think that works. Ultimately, the time-tested principle that a judge speaks through his order must prevail.
Any more comments? I think we're well over time, so I am going to just thank my panelists and all of you and say thank you and well done.
On behalf of the panelists, I want to thank Shaneen for really keeping all this together and really leading us well. Thank you.
So, ladies and gentlemen, we've come to an end of this very productive Friday evening. As Gloria said in the beginning, this has been a very special conference for us. While virtual events kept the exchange of ideas in international arbitration ongoing, I think in-person forums are indispensable to keep the passion for international arbitration strong. So on behalf of SIAC, I'd like to thank all the speakers for their insights and expertise, and particularly like to thank Professor Jan Paulsen for his keynote speech, the single most important thing about international arbitration, which I'm sure will become a point of reference in many discussions ahead. Lastly, I'd like to thank you, the audience, for taking out the time to join us today, and now invite you to join us for drinks. Thank you so much for being here with us.